So these are 5 cases where I find union as a party. In the cost list, there's 18, 27, 33, 35, and 36.
Look, may I seek your lordship's permission just to say 2 words with a kind, the learned attorney would permit me. There was one aspect which may not have engaged your lordship's attention, that though the code had been brought into force on 21st November 2025, the 2 laws were running in tandem and parallel. But on 2nd February 2026, a notification came to be issued formally repealing the Industrial Disputes Act, the Trade Unions Act, and the Industrial Employment Standing Orders Act. My lords may not, I'm not sure whether...
These are not formally on record.
So there's a formal repeal. So now we are considering...
20 Act, 104 section of 2020, the new act, said these acts shall be repealed.
Yes.
Shall be repealed by issuing separate notification.
Yes, but that had somehow escaped their attention. So 2 notifications were issued on 21st November and 8th December, but both of them, they had not executed the formal repeal. That comes on 2nd February. So today, my lord, the situation is that now the
Industrial Dispute Act is
now section completely repealed, and now there's a section 6 of the General Clauses Act and 104 of that governs the thing. So we are really only on the pipeline matters now, which might be in the pipeline under a repeal statute.
pipeline or pending before different forms as you...
In that sense, pipeline, which are pending before your lordships or pending in some high court. But the definition which we are considering here no longer exists.
Exactly.
And the new definition now has formally taken over. It's not running in tandem or parallel anymore. If I can just place those notifications, if it is of assistance to your
This
lordship.
was keeping in mind this aspect, the subsequent events and the new legislation. That's why on 16th February 26, the day when we kept it for directions, and in para 4 and 5.
I saw that, Manoj. I saw that.
Pipeline was also keeping this mind that the issue is now stand quite shortened. It's only for the, as you rightly say, for the transitional matters which originated at the time when the old act was there, until it has been first substituted by in 2020 by the new act and now formally repealed.
Now formally repealed. So only that formal repeal was perhaps not drawn to your lordship's attention on 16th February. And there's also an amendment act of 16th February. In the code has been amended formally by Parliament to encapsulate that repeal.
Yes. You can ask your junior to
We have made a compilation of the 3 notifications.
Yes.
Just for your lordship, the 3 notifications of 21st November, 8th December, and 2nd February are all 3 there. Just for...
Well, there is, with your permission, there is one more issue I'd like to flag before the formal hearing begins. My Lord, I would like to alert this court to the possibility that any judgment rendered by this court on the interpretation of the old law will have an impact on the new law. And this, my Lord, may not be fair to us on this side, because now the 2 sides are pretty clear, my Lord. There is one side asking for the reconsideration of Bangalore water supply, and there is this side saying it need not be reconsidered. Now, my Lord, my question for consideration is this. Whatever view your lordship takes of the matter will definitely have an impact on the new law, the definition of industry under the new law, my Lord. And we are not here called upon to address you on the question of the new law. Therefore, my Lord, this danger has to be averted. How do we avert this danger, my Lord, without transgressing into the constitutional validity of the new law, which, my Lord, we want to keep it as an issue which will be raised in times to come. As of today, my Lord, there is no petition pending before you.
That much clarification can be given. That while taking a view with respect to whether the Bangalore water supply or with respect to the original definition under the repealed act, while construing or interpreting that part, I think that if the word of caution can always be put that this interpretation only relates to the law as it used to be at that time.
My Lord, yes. But with respect, my Lord, there is an unavoidable overlap. For the reason, my Lord, I wish to make it clear, my Lord, so that my rights are protected, that's all. The point is, there is an unavoidable overlap between what your lordships may decide and what the new law says. But what the new law does is, basically, the crux of the matter today, as far as I see it, is the request on the other side to remove charities and from the
So we are
purview.
hearing that matter for the time being because
But because the new law removes it. Now, the point is we are going to challenge that removal of charities from the new law, and also very wide definition of social work.
any
All social work is excluded from the new law.
that challenge we will independently deal with.
It's true, Milord, but your lordship's judgment will
Just to put it in a different.
find us as far as any challenge to the new law is concerned, Milord. Therefore, I wish to make it clear. All submissions are completely without prejudice to our contention.
Yes,
The
yes.
new law is liable to challenge.
Yes, that of course.
That
we
you
clarify.
should keep in mind, because
Just put it on a different.
submission will be without prejudice.
Put it on a slightly different track, taking you from a front submission. Imagine that this bench is today assembled to look into a challenge to a new law. Imagine. And then the court will find out whether after a repeal of earlier law and a judgment which prevailed with an earlier law, will it cast a shadow on the new law at all? The court will see it from an entirely different angle.
True.
Entirely different angle. Therefore, whether without a challenge to the new law, as today court is not confronted with
No, I
that.
just want to clarify one thing. There is a challenge to the new law.
Not before this bench.
Can I just complete? It's writ petition 26330.
Mr. Gopal, if there is, we will separately
No,
examine
I'm
that.
just saying we need to
Not
bear in
that.
mind that Parliament has taken a call on the
We
definition
hope
and
that
exists.
we bear in mind, and that much
Yes.
basic understanding we possess.
No, no.
Now let us
No,
start.
I'm just
The
clarifying
valid
that-
has started already. I have fixed the
I'm
time. We
saying
will
that-
not allow anything to
That
go beyond that.
It is pending.
Let's start,
The Lordship
please.
may consider it at some point.
Yes, Mr. Dangu.
Yeah, Your Lordship. And it's personally speaking, it's I have a lot of reflections and remembrances to what might have gone into the mind of the learned judge who authored his opinion. And in a manner of speaking, it's a kind of a Kurukshetra here. Now there are only Pandavas on either side. There are no Kauravas and Pandavas. Because both are articulating some various issues on some very common concern. But why is that the court is now called upon?
Yes, please.
Why the court is now called upon to answer this question at all? But an easy answer would have been that the new law has come, it has taken over the field, and whenever there is an application of new law, and whatever the precedents occupy the field under the old law, or otherwise repealed or amended or whatever it is, they may be cited in support or cited in opposition under the formulations of the new law. But then we're not arguing in the abstract, because what happened is the new code, the 2020 code, as to a considerable extent, picked up from paragraphs 140 and 141 of the Bangalore water supply. The new definition has picked up something from the judgment. But then the trouble or the question still remains as to number of illustrations which the Bangalore water supply looked into, various activities the Bangalore water supply looked into, and answered either way. They may continue to arise, time and again in future. Particularly instances like charitable institutions, philanthropic institutions, education, or by and large governmental functions. So therefore, when Bangalore water supply was heard, and then if a lot will see Bangalore water supply right from Banerjee onwards, goes by and large to a large extent on Australian precedents. And because our Industrial Disputes Act was also borrowed to a considerable extent on the Australian law. So more than 1904, 1910 Australian experience. And that's how Banerjee onwards, there was a long discussion on why a large, wider import of the words used in the industrial definition of industry came to be considered. So today, if the court were to say, in terms of the issues framed, can I take your lordship that the court has framed the issues for consideration in the order dated 16th of February. We have our compilations in volume 1 of my volume 5B. Volume 5B of the compilation. We have made available hot copies also for the court.
4B and 5B for the proper definition. 4B and 5B.
Obviously. I'll be referring to volumes 4B and 5B, which are compilations filed on behalf of the Attorney General. And my written submissions in volume 1A.
1A. Yes, please.
Your Lordship, at page 139 is the order where Your Lordship framed issues. Let me read them and then place my humble observations on how do you go about with answering these issues. Issue number one, I find issue number one has two parts. Whether the test laid down in paragraphs 140 to 144 in the opinion rendered by Honorable Mr. Justice V.R. Krishna and so and so,
It's
to
basically
determine if an undertaking or enterprise,
page
139. Volume 5B.
total cited. Rani, these are only these judgments which are being relied upon. 139.
At page 139, this compilation has an entire set of judgments, including Bangalore Water Supply, and then earlier.
All 37 judgments are.
That's right. But I'm reading at page 139.
No, it is the order dated 16th February.
16th February 2020, by which Your Lordship framed the issues for consideration by this 9. We don't have hard copy. Let them.
Page 139.
Issue, page 139, issue number 1. Whether the test laid down in paragraphs 140 to 144 in the opinion rendered by Honorable Mr. Justice Krishna in Bangalore Water Supply to determine if an undertaking or enterprise falls within the definition of industry and lays down the correct law. I pause here for a minute. The issue, I think, is advisedly framed like this to only go into the question whether an undertaking or an enterprise falls within definition of industry and lays down the correct law. Now, and whether, second part of it, and whether the Industrial Disputes Amendment Act 1982, which seemingly did not come into force, and the Industrial Relations Code 2020, section so and so, have any legal impact on the interpretation of the expression industry as contained in the Principal Act. So if I consider these as two issues, two separate issues, and because they may have those significance, so let me, then the second issue, whether social welfare activities and schemes or other enterprises undertaken by the government departments or their instrumentalities can be construed to be industrial activities. The issue also again advisedly uses the word enterprises. Then for the purpose of section 2J of the ID Act. Now, 3, what state activities will be covered by the expression sovereign function, and whether such activities will still fall outside the purview of section 2J of the ID Act, any other issue that may arise. Now, I think it's important for us then to go back in point of time to the referral order. The earlier order, referral order as we call it, which is in the same volume at page 94, which is a reported judgment, 2005, 5 SCC 1.
Yes, we have got it 90.
Yes, the judgment begins at page 102.
Jabir Singh matter.
That's right. Let us look at a couple of paragraphs which probably persuaded this court to enter into a question of a reference, para 2, at page 102, on the question whether Social Forestry Department of State, which is a welfare scheme undertaken for improvement to the environment, would be covered by the definition of industry under section so-and-so. The aforesaid benches, which are noticed in paragraph 1, of this court culled out differently the ratio of the 7-judge bench decision of this court in the case of so-and-so. And both of the 3 judges in the case of Chief Conservator of Forests in Kondera, and based on the decision of Bangalore water case, came to the conclusion that the Social Forestry Department is covered by the definition of industry, whereas the 2-judge bench decision in so-and-so took a different view. And the cleavage of opinion between the 2 benches of the court seems to have been at the basis of the 7th bench decision of the court in so-and-so. The present case, along with the other connected cases, the correctness decision in the case that was doubted has been placed before the bench. Various decisions rendered by the court prior to and after the decision in Bangalore water on the interpretation of the definition of our industry and the Industrial Disputes Act have been cited before us. It's been strenuously urged on behalf of the employers on the expansive meaning given to the word industry with certain specified exceptions carved out in judgment Bangalore water is not warranted by the language used in the definition clause. It's urged the government and the department, while exercising its sovereign function, have been excluded from the definition of industry. On the question of what is sovereign function, there is no unanimity in the different opinions expressed by judges in Bangalore water case. It is submitted that in a constitutional democracy, the sovereignty vests in the people all welfare activities undertaken by the state in the discharge of its obligations and the directive in state policy contained in Part 4 of sovereign function. To restrict the meaning of sovereign function to only specific categories of so-called inalienable functions like law and order, legislation, judiciary, administration, the like is uncalled for, submitted that the definition of industry given in the Act is no doubt wide, but not so wide as to hold to include all kinds of systematic organized activities undertaken by the state and even individuals engaged in the professional philanthropic activities. Then, on behalf of these, I'll skip paragraph. On behalf of the employers, it also pointed out that there is no unanimity in the opinions expressed by the 9 judges in Bangalore water case on the ambit of definition of industry given in the Act. Pursuant to the observations, the legislature responded and amended the Act by the Industrial Disputes Amendment Act 1982. In the amended definition, certain specified types of activities have been taken out of the purview. The word industry Act stands amended, but the amended provision redefining the word industry has not brought into force because notification to bring this provision, the effect has not been issued in accordance with subsection 2, section 1, the amended Act The amended definition thus remains the statute unenforced a period now more than 23 years. Now kindly switch over to the long discussion, Bangalore water supply. Page 110, paragraph 18. There is some point of view that there is a difference of opinion among the judges, but I think it's in a very narrow area. And paragraph 18, Krishnaya himself who delivered the main judgment in Bangalore water at various places in his opinion expressed that the attempt made by the court to impart a definite meaning to the words in the definition history is only a workable solution until a more precise definition is provided by the legislature. See the following observation. Our judgment here has no pontifical flavor, but seeks to serve the future, however, till changes in the law or industrial culture occur. That's important words. Law, especially industrial law, which regulate the rights and remedies of the working class, unfamiliar with the sophistications of definitions and shower of decisions, unable to secure expert legal opinion about what poverty pricing or the justice market, and denying them the staying power to withstand the multi-docket litigation de facto deny social justice. If legal drafting is vigorous and definitions indefinite and court rulings contradictory. Is it possible that the legislative chambers are too preoccupied with other pressing business to listen to court signals calling for clarification of ambiguous clauses? A careful prompt amendment of Section 2J would have preempted the docket explosion before tribunal and court. I pause here. And then kindly come to paragraph 19. Again, paragraph 145. The court echoes the same. I'm going to read it once again in the course of my submission. 145 is extracted in paragraph 19. I read paragraph 145. We conclude with a diffidence because Parliament, which has a commitment to the political nation to legislate promptly in vital areas like industry and trade and articulate the welfare expectation in the constraints portion of the Constitution, has hardly intervened to restructure the rather clumsy, vaporous, and tall and dwarf definition or tidy up the scheme. Therefore, the court, does Krishna himself think the definitions of industry were clumsy, vaporous, and tidy and all that? I'll come back later about that. Then come to a paragraph in the next page, paragraph 21. Just keep it here. The dissenting opinion of Justice Jaswant Singh for himself and Tulsa Mukherjee concludes with the following observation. In view of the difficulty experienced by all of us in defining the true denotation of the term industry and divergence of opinion in regard to that too, as has been the case with this bench also, we think it is high time the legislature steps in with a comprehensive bill to clear up the fog and remove the doubts and set at rest once for all the controversy which crops up from time to time in relation to the meaning of the aforesaid term, rendering it necessary for larger benches of this court to be constituted, which are driven to the necessity of evolving a working formula to cover particular cases. By the time we did not have the 2020 court, we are still awaiting Parliament. Court thought Parliament is still yet to act. So the above observations contained the dissenting view of Justice Jaswant Singh have proved prophetic. The legislature has intervened and amended the definition of industry in 1982, but for more than 23 years, the amended provision has not been brought into force. The unamended definition with the same vagueness and lack of precision continues to confuse the courts and the parties. I may not agree with that observation, but I'll come to it later. The inaction of the legislative and executive branches has made it necessary for the judiciary to reconsider the subject over and over again in the light of the experience of the working of the provisions on the basis of the interpretation judgment in Bangalore Water rendered as far back as the year 1978. The next paragraph. In the case of Koi Board, a two-judge bench, as court speaking to Sujata Manohar J, surveyed all previous decisions of the court, including the seven-judge decision in Bangalore Water, and passed an order of reference to the Chief Justice constituting a larger bench or more than 7 judges if necessary, the following part of the order. Since the difficulty is arisen because of the judicial interpretation given to the definition of industry in the Industrial Disputes Act, there is no reason why the matter should not be judicially re-examined. In the present case, the function of the Koi Board is to promote coir industry open markets for it, and to provide facilities to make the coir industry's products more marketable. That's in the nature of a service. It's not set up to run any industry itself. Looking to the predominant purpose for which it is set up, we would not call it an industry. However, if one were to apply the test laid on Bangalore Water Supply, it is an organization where there are employers and employees. The organization does some useful work for the benefit of others. Therefore, it will have to be called an industry under the Industrial Disputes Act. We do not think that such sweeping tests as contemplated the Industrial Disputes Act, nor do we think that every organization which does useful service and employs people can be labeled as industry. We therefore direct the matter to be placed before the Honorable Chief Justice to consider larger bench should be constituted so and so. In the next paragraph, when the matter was listed before a bench, three-judge bench, the request for constituting a larger bench for consideration of the judgment so and so was refused both on the ground that the Industrial Disputes Act has undergone an amendment and that the matter does not deserve to be referred to a larger bench as the decision of 7 judges bench is binding on the benches of this court or less than 7 judges. The order refusing reference to 7 judge decision by so and so reads thus. We have considered the order made in civil appeal so and so, delivered almost 2 decades ago. The law has since been amended pursuant to judgment, though the date of enforcement has not been notified. The judgment delivered by so and so does not, in our opinion, require any reconsideration or reference being made by a 2-judge bench as court is bound by judgment larger bench. The appeal therefore be listed before the appropriate bench for the election. Thus, the reference sought by 2 judges to a larger bench of more than 7 judges was declined by 3-judge bench. As has been held by this court subsequently, in the case of Central Board of Dawudi Bora, the so-and-so, it is open to the Chief Justice and the reference made by the 2 honorable judges to constitute a bench of more than 7 judges for reconsideration of the decision in Bangalore Water Supply. 24, next page. In any case, no such inhibition limits the power of the bench of 5 judges which has been constituted on a reference made due to apparent conflict between judgments of 2 benches of this court. As has been stated by us above, the decision in Bangalore Water is not an unanimous decision. Of the 5 judges who constituted the majority, 3 have given a common opinion, but the 2 others have given separate opinions projecting a view partly different from the views expressed in the opinion of the other 3 judges. Beg CJ, having retired, had no opportunity to see the opinion delivered by the other 2 judges subsequent to retirement. Krishna J and the 2 judges who spoke to him did not have the benefit of dissenting opinion of the 2 other judges and a separate partly dissenting opinion of Chandrachud Dey, as those opinions were prepared and delivered subsequent delivery of the judgment in Bangalore Water case. Probably that seems to the dynamics of this court with its combination of benches of more than 2. In such a situation, it's difficult to ascertain whether the opinion of Krishna J given on behalf of Bhagavati and Desai JJ can be held to be an authoritative precedent, which would require no reconsideration, even though judges themselves expressed the view that the exercise of the interpretation done by each one of them was tentative and is only a temporary exercise till the legislature stepped in. The legislature subsequently amended the definition, but due to lack of will both on the part of the legislature and the executive, the amended definition for a long period, 23 years, has remained dormant. Sri So-and-so appearing for National Remote Sensing Agency, which is an agency constituted by the government in discharge of its sovereign function dealing with defense, research, atomic energy, and space, falling in the excluded category in subclass 6 with the amended definition industry in section 2J, relies on the following decision in support of its submission that where the unamended definition in the Act is ambiguous and has been interpreted by the court not exhaustively but tentatively, until law is amended, the amendment actually brought into the statute can be looked into for consideration for construction of the unamended provision. Then next paragraph. Andhyajana further argued that the Industrial Disputes Act 1982 noted the views not only of the definition of industry as provided in various other provisions, the Principal Act also amended. Subsection 2(1) of the Amendment Act say the Act shall come into force in that day so and so by notification the official gazette point. It submitted either the whole of the Act should have been notified for enforcement or not at all. The Amendment Act does not contemplate a situation where the central government notify only some other provisions of the Amendment Act for enforcement and withhold from enforcement other provisions, Amendment Act. It's argued that such piecemeal enforcement act is not permissible by subsection 2, so and so, it is Benian. Then little later, and then I skipped that particular paragraph, come to paragraph 28. Senior advocates with Jay Singh and Colin Gonsalves, counsel appearing for the employees very vehemently oppose a prayer made on behalf of the employers for referring the matter to a larger bench for reconsideration of the decision Bangalore water case. I think they have the same stand today. It is submitted that even though the definition of the industrialist books have been amended in 1982, it has not been brought into force for more than 23 years, and the reason disclosed to the court when the enforcement of the Amendment Act was sought in the case of Ultimate Shreen in its sound justification, the stand of the UN of India was for the category of industries. Excluded the amended definition, no alternative industrial dispute resolution forums could be created. For the opposite reason, the central government did not enforce the provision of the Amendment Act, which provided a new and restrictive definition of industry. Then the council with the employees relied on AKRI in support of submission that did not open to the court to issue the amendments to the government to bring into force the provisions of the Act. Submitted that the prerogative of the government in accordance with the provisions of the Amendment Act to enforce the provisions of the Act when it finds that there are conditions suitable to take out the purview of the definition of industry, certain categories of industries in which the employees have been provided separate forums for redressal of the industrial disputes. Then paragraph 30, on behalf of the employees submitted pursuant to the decision, although the legislature responded by amending the definition of industry to exclude certain specified categories of industries from the purview of the Act, employees of the excluded categories of industries could not be provided alternative forums for redressal of the grievance. The unamended definition of industry as interpreted in Bangalore Water has been the settled law of the land in the industrial field. The settled legal position has operated well, and no better enunciation and scope and effect of the definition could be made either by the legislature or by the Indian Labour Organization in its report. That's a very ambitious statement. Then kindly come to the court looks at paragraph 35 at page 117.
33 also.
Where fire board is referred to, and for good reason they're referring to paragraph 19. After para 19, which I read out earlier at page 118, this is how the referral order reads. The above quoted observations were criticized on behalf of the employees, stating that for making them, there was no material before the court. We think that observations learned judges are not without foundation. The experience of judges in the apex court is not derived from the case in which the observations are made. The experience was from the cases regularly coming from to the court, to the labor court. It is experienced by all dealing in industrial law that overemphasis on the rights of the workers and the undue curtailment the rights of the employees to organize the business through employment and non-employment has given rise to a large number of industrial and labor claims resulting in awards granting large amounts of back wages for past years, allegedly as legitimate dues that the workers are found to have been so and so. Then after placitum, yes, the awards of reinstatement and the arrears of wages for the past year of labor codes by treating even a small undertaking of employers and entrepreneurs as the industry's experience as a serious industrial hazard, particularly by those engaged in private enterprises. They experience that many times idle wages are required to be paid to the worker because the employer has no means to find out whether and where the workman was gainfully employed pending adjudication. The exploitation of workers and the employers has to be equally checked. Law, and particularly industrial law, needs to be interpreted as to ensure that neither the employers nor the employees are in a position to dominate the other. Both should be able to cooperate for their mutual benefit, the growth of industry, and thereby serve the public good. An over-expansive interpretation might be deterrent to private enterprise in India where public employment opportunities are scarce. The people should therefore be encouraged towards self-employment, embrace within definition of industry even liberal professional like so-and-so and the like, which are occupations based on talent, skill, and intellectual attainment, is experienced as a hurdle by professional self-asserts in carrying on their profession in a city. No doubt, even liberal professions are required to be regulated and reasonable restriction imposed. If you adopt an ideological, philosophical approach, we would be treading on the wrong path against which learned Sri Justice Krishna himself recorded a caution in his inimitable style thus. Here we have to be cautious not to fall into the trap of definitional expansionism, bordering on reductio ad absurdum, not to truncate the obvious amplitude of the provision to fit into our mental mold of beliefs and prejudices or social philosophy conditioned by class interests. Subjective, it shall not be further to the forensic thought. If credibility with a pluralist community is a value to be cherished. Courts do not substitute their social and economic beliefs for the judgment of legislative bodies. I think very often we take a different note on this. Of course, courts do, but then how far they can do is a different question. So a worker-oriented approach in construing the definition of industry, unmindful of the interests of the employer or the owner of the industry and the public who are the ultimate beneficiaries would be a one-sided approach and not in accordance with the provisions of the Act. We also wish to enter a caveat on confining sovereign function to the traditional so described as inalienable functions comparable to those performed by a monarch, a ruler, or a non-democratic government. The learned judges in Bangalore Water Supply seem to have confined only such sovereign functions outside the purview of industry which can be termed strictly as constitutional functions of the three wings of the state, executive, legislative, and judicial. The concept of sovereignty in a constitutional democracy is different from the traditional concept of sovereignty, which is confined to law and order, defense, lawmaking, justice dispensation. In a democracy governed by the constitution, the sovereignty of the people and the state is obliged to discharge its constitutional obligation contained in the directive principle of state policy. From that point of view, wherever the government undertakes public welfare activities in discharge of its constitutional obligation, as provided in Part 4 of the Constitution, such activities should be treated as activities in discharge of sovereign functions falling outside the purview of industry. That's what your Lordship want to look at in the second and the third issue. Whether employees employed in such welfare activities of the government require protection, apart from the constitutional rights conferred on them, may be a subject of separate legislation. Please kindly mark it. May be a separate subject of separate legislation, but for that reason, such governmental activities cannot be brought within the fold of industrial law by giving an undue, expansive, and wide meaning to the words used in the definition of industry. In response, Parliament intervened and substituted the definition of industry by including with its meaning some activities of the government and excluding some other specified governmental activities and public utility services involving sovereign function. For 23 years, the amended definition has remained unenforced. Government has been experiencing difficulty in bringing into effect the new definition. Issuance of notification has been withheld so far. It is therefore high time for the court to re-examine the judicial interpretation given by it to definition of industry. The legislature should be allowed to greater freedom to come forward with a more comprehensive legislation to meet the demands of employers and employees, the public and private sectors. The inhibition, the difficulties arise being exercised by the legislature and the executive in bringing into force the amended industrial law, more due to judicial interpreted definition of industry need to be removed. The experience of working with the Provisions Act should serve as a guide for a better and more comprehensive law on the subject to be brought into force without limitation. Now that we have reached that stage, 1982, a unnotified law is no longer part of the canvas. So now that we've reached the 2020 code, a couple of questions may arise in your mind. As Ms. Jay Singh was trying to canvas. Now, what is that important public purpose that will be served by this court looking into the Bangalore water supply in its expansive sweep and say that in one way or the other, to some extent or the other, the Bangalore water supply is not good law. There has to be some impact factor, I suppose. Is it because the new code, which is partly lifted from Bangalore water supply in the definition of industry, but partly departing from it? Therefore, if your Lordship say that it's partly good law, certainly is going to carry on and have its cast a shadow on the application interpretation of the new code. But to say on the other hand, no, don't do it at all. The new code will take care of itself. Therefore, there is some problem where the court may have to very carefully tread. So the court were to say, well, it's good law for all practical purposes. And the new code will certainly receive its color from this court's imprimatur of the Bangalore water supply. And to what extent that exercise will be undertaken is also a question for Lordship's consideration. And let me complete this and then come to it. Paragraph 42.
Yes.
I'm leaving for the time being paragraph 41. Paragraph 42. In construing the definition and definition clause and determining its ambit, one has not to lose sight of the fact that in activities like hospitals and education, concepts like the right of the workers to go on strike or the employer's right to close down and lay off are not contemplated because their services, in which the motto is service to the community, if the patients or students are to be left at the mercy of the employer and the employees, exercising their rights at will, the very purpose of service activity would be frustrated. So we are respectfully inclined to agree with the observations of Jadendra Gadkar in Harinagar case, as we have repeatedly emphasized. In dealing with industrial matters, industrial adjudication should refrain from enunciating any general principle or adopting any doctrinal considerations. It is desirable that industrial adjudication should deal with problems as and when they arise and confine a decision to the point which strictly arise on the pleading between the parties. That's a very, very ambitious statement, if I can put it like that. Because when you have issues like an industrial definition, to say that can be no room for doctrinal considerations is going to be a problematic statement. But that apart, the court is only bringing an attention to the fact that notwithstanding those doctrinal considerations, can you go beyond them to the extent that's possible? That's what perhaps Jadendra Gadkar is talking about here. We conclude agreeing with the conclusion of honorable judges in Hospital Madhu Sabha. Though Section 2J use words a very wide denotation, a line would have to be drawn in a fair and just manner so as to exclude some calling, services, or undertaking. This court must therefore reconsider where the line should be drawn and what limitations can and should be reasonably implied in interpreting the wide words in Section 2J. That, no doubt, is rather a difficult problem to resolve, more so when both the legislature and the executive are silent and have kept an important amended provision on the law dormant on the statute book. We'll come to it.
The new code. It's in different bodies.
I've taken my note. My note. Fines. Fines should be noted.
So when you go to Bangalore water supply.
You may read para 45 before concluding this judgment.
Your Lordship, please, sir.
You may just read para 45 also.
Yes, yes. I'll come. We do not consider it necessary to say anything more and leave it to the larger bench to give such meaning and effect to the definition clause in the present context. With the experience of all these years and keeping in view the amended definition of industry kept dormant for long 23 years, pressing demands for the competing sectors of employers and employees, and the helplessness of so and so, the Amendment Act compels us to make this reference. So perhaps that's what persuaded your Lordships to have the second part of issue 1, which says what is the impact of amended 1982 amendment and the current code.
We may add one more angle to this matter. Bangalore water supply is a judgment which came in 1970s. We have the reforms of 1991, which has focused on liberalization, privatization, and globalization. Now, if there is going to be more focus on privatization and liberalization, many of the functions which the state was doing would be performed by the private sector. Then what should be the scope of the definition of industry? Should it still be very expansive, or should it be restricted, or a balance has to be struck? I think that is one of the angles of this case, since that judgment is delivered almost half a century ago.
Correct.
Now we are in 2026, and we have had how many years of liberalization? I say LPG, liberalization, privatization, globalization.
Correct.
Which is so important for a woman also, LPG.
No.
All I say,
Not,
so for a woman,
there's no shortage. There's no shortage of LPG.
Get it?
There's no LPG shortage today here, as far as that is concerned.
small typo.
No, responding to your Lordship's observation, let me place the.
Half a century ago, we were on socialist philosophy, and you know what has happened in the property owners case,
That's right.
Ranganatha Reddy, etc.
Right. It's a very important observation.
Yes.
Let me respond to it quickly before I go into the larger question. Now, whatever socio-economic changes happen in a community or a country, particularly where you're talking about liberalization, etc., globalization, privatization, opening up market in a big way, the question will still remain if the definition of industry in 2J had continued to occupy the statute. Then, of course, we need to call in the context of a definition which remains unchanged, whether Bangalore water supply would continue to provide us enough guidance, or we need to go a little away from that or move away farther from that. But today, since we don't have that situation at all, we have both a 1982 interlude, not notified, and a later code which is now occupying the field. Therefore, I think Lordships will have to probably answer these issues in a very narrow perspective as to whether between 1978 to 2020, will it be a good only for the purpose of answering those matters which are pending before the court?
Yes.
That's
Matters are
That's
pending
right.
before
If
the
it's
court.
only for a limited purpose, then of course,
How they can't.
court need not travel a long line of entering into all the debates about what would be sovereign functions, so on and so forth. But if it's for a larger, canvas, then I think I would probably tell the court, be slow in looking into this issue, because the new code, to a considerable extent, has borrowed from para 140 of the Bangalore water supply, but has departed in certain respects. For whatever the court may say today, whether Bangalore water supply in its entirety or partly or ruled, partly approved, or whatever it is, will certainly cast a shadow on the interpretation of the new code. To the extent it has some overlapping. Therefore, I thought it was only for the purpose of answering and responding to the matters pending prior to 2020. Perhaps we walk on a very narrow path. We walk on a very narrow path. Many larger considerations need not enter the mind of the court in unraveling Bangalore is a good law, a bad law, doctrine, no doctrine, etc. So I thought that's something I'm not very clear whether.
It should be activity based.
Yes.
For example, social forestry. Yes. Activity based has to be considered.
May I presently place therefore how, for instance, from 2J in the 1947 Act, 1982 definition, and then the current definition. I'll quickly place that so that we have a perspective on where we should probably stop and where perhaps the logos will not go further. Now, kindly take in the compilation.
Just one question.
I'm sorry.
This is referred to para 45.
Yes.
Now, where do we find in the judgment what the pressing demands of the competing sectors were and what difficulties were faced by the legislature and the executive to enforce the amended definition of industry, which compelled the 5-judge bench to make the reference? Where is that discussion?
No, they go through. There are 3 or 4 cases which have been dealt with. Kindly come back to paragraphs.
No. Paragraph 45 as mentioned refers to, this is the final conclusion, that it is because of the pressing demands and the helplessness of the legislature and executive that we are making a reference.
No, the court goes back to Bangalore water supply itself to say that Bangalore water supply, both in terms of Justice Krishna's judgment and the opinion by Justice Jaswant Singh and Justice Tulsapurkar, and partly Justice Chief Justice Chandrachud, also take note of it. Now I think that's where, yes.
Please come back to 45.
Yes.
It refers to an incident which was not there when Bangalore water supply was decided. They say that the legislature and the executive are helpless in bringing into force the Amendment Act. That is 1982.
Yes.
That was not there in Bangalore water supply. It precedes 1982 amendment. What prevented the legislature and the executive to enforce the Amendment Act, which is compelling the 5 judges bench to refer it to the Chief Justice? Where do we find that?
No, there is no.
It's not there?
No, there is no material available in the judgment.
In the judgment.
But then,
If it is not
then
there,
I have placed on record.
what is, we would, at least I would be questioning you,
Yes.
whether it's a valid reference.
No, but
Whether it's a valid reference, first.
yes.
Secondly, the bench has, in paragraph 24,
Yes.
has repeatedly said, this is not an unanimous opinion.
It is.
Madam, just 1 minute.
24, yes.
24,
Bangalore water supply, fourth line is not a unanimous decision. Of the 7, 5 were on one side, 2 were on the other side. How is it relevant?
No, I'm not.
Seven-judge bench, it has to be considered as a 7-judge judgment.
Let,
Srimurthy Fragrances
Let-
quite recently says,
yes.
irrespective of the number of judges dissenting, it has to be taken as the judgment.
I'm not here to support that at all.
Not
Now, let's look at it from.
Lead opinion which has to. That is the law. There may be.
Yes.
Let me put
This
it.
is the first thing. The 5-judge bench says that it is not a unanimous, as if this is a ground for making a reference. Secondly, Justice Iyer, on behalf of Bhagwati and Desai JJ, whether it can be held to be an authoritative precedent. A 5-judge bench questioning the 7 judges bench.
Yes.
No, that's why when this difficulty arose.
When referring to
That's why when the difficulty
Dr. Manohar's judgment, which was placed before a larger bench, the larger bench did not agree with the 2-judge bench and did not refer.
That's when the difficulty arose. Kindly turn to why
social funds.
They were different opinion.
at page 113 the court when the earlier endeavor in choir board did not meet with approval by a subsequent 3 judges bench at page 113 bottom. That's how these references ultimately been made. So I do not know. I do not know. I'm. To come back to page 113.
Apropos what fell from my Lord
And then
Justice
there is
Datta, I can just point out one more, one more aspect, my Lord.
We will not permit Mr. Ansari.
Let me
Ignore the way to, let him complete first of all.
page 113 at the bottom.
Anyone to interrupt?
Page 113 bottom. So the reference sought by the two judges to a larger bench was declined by 3 judges bench, as has been held by the court subsequently in the case of Central Board of Dawudis also.
113, where are you?
Is open to the Chief Justice.
Paragraph?
Page 113 at the bottom. It at the bottom of that page.
Thus, the reference sought by 2 judges to a larger bench or more than 7 judges were declined by the 5 judges bench. Rightly so, because that's contrary to rules.
Perhaps this is also
Then as has been-
statement, Mr. Attorney.
One minute, let me,
Judges can refer it to 3, 3 to 5, 5 to 7,
That's
and
so-
this is the course that has been followed.
let me complete the
Not
history.
You can directly refer it to
Let
7.
me complete the history. That's right. I'm not yet completed the history. So that's how I think it came before a bench of 5 judges. Now kindly turn to page 1, 2, 3.
This last line is absolutely correct statement of law, because under the Supreme Court rule, Chief Justice.
The
has-
Chief Justice takes a call on that, and the 5 judges bench is constituted. The 5 judges bench take a view that there is a need for a reference, and then the matter goes before a bench of 7 judges at page 123, and we have the order at page 125. So, in a manner of speaking, when the 7 judges bench place its stamp of approval on the reference, that's how, now it's before your lordship, page 125. You will learned counsel for the parties at considerable length, been taken through so and so, and the reference order passed by a 5 judges bench of the court pursuant to which these matters have been placed before us, having given our anxious consideration to the contentions urged at the bar, and the serious and wide-ranging implications of the issue that fall for determination, as also the fact that serious doubts have been expressed in the reference order about the correctness of the view taken and so on. So, we are of the opinion that these appeals need to be placed before a bench comprising 9 judges to be constituted by the Chief Justice. We ordered accordingly papers to be so and so. Therefore, a 7 versus 7. Bangalore 7, this 7. Therefore, I don't know whether that part of a referral process need to halt your lordship on the further.